Of the Troubles, David Davis.
Thank you, Madam Deputy Speaker. Can I start by welcoming the Secretary of State to his place? We all know that Secretary of State don't have to answer adjournment debates, and he and I will, of course, have robust differences of view on this, but no one can gainsay either his courtesy or his commitment to the task, and so I thank him for being here. Now, in the coming weeks, we'll be asked to consider legislation addressing the legacy of Northern Ireland. And we must approach this with the real facts of what happened in Northern Ireland, not the misinformation peddled by the IRA and their sympathisers. We should also remember the state has a moral obligation to protect brave soldiers who defended our freedoms in the most testing circumstances. This is not simply a question of policy detail. It's a question of principles. The principle that we do not abandon those who acted under our lawful instruction. The principle we do not risk weakening the effectiveness of our armed forces. And the principle we do not bend to the demands of terrorists or indeed their modern sympathisers. And the government's proposed legislation, I'm afraid, does little to show any willingness to defend those principles, to which I'll return shortly. In the Westminster Hall debate in July, we heard Labour MPs, government-supporting MPs, argue, and I quote exactly, "The only thing that grants immunity to former members of the IRA is the Northern Ireland Legacy Act as it stands." That's the Conservative Government Legacy Act. That is plain wrong. The truth is, there has long been a de facto amnesty for crimes committed during the Troubles. Blair's government created the Good Friday Agreement, an agreement for the purpose of achieving peace, a good aim, for the purpose of achieving peace, drew a line under the atrocities that have been committed without resolving the complex issues of accountability. Now, the Good Friday Agreement contained a provision for early release of convicted prisoners. 483 terrorists were released from prison early, effectively pardoned. 143 of those released have been sentenced to serve life sentences. 143, inevitably including many killers. At least 16 terrorists were also granted the royal prerogative of mercy, also effectively a pardon. And those granted the royal prerogative of mercy included hardened terrorists guilty of extreme violence. Jerry Kelly, convicted for the Old Bailey bombings, which killed one person and injured over 200. The 3 IRA terrorists who murdered SAS Captain Herbert Westmacott. Fergal Toll, who held down his victim's arms while 2 of the victim's fingers were hacked off with a hammer and chisel. All of these people received the prerogative of mercy. It was also the Blair government that authorised the so-called on-the-run administrative scheme. That's its formal title, the on-the-run administrative scheme, and the letters of comfort that accompanied it. A secret scheme that only came to light properly in 2014, years after terrorists had received their letters. It was kept secret precisely because it was so spectacularly controversial. And it was done in response to Gerry Adams saying, and I quote, "It would be better if there was an invisible process for dealing with on-the-runs." And the name speaks for itself. These people were on the run from the law. It was an administrative scheme, precisely because attempts to legislate for it were dropped when Sinn Féin opposed them on the grounds it would have protected soldiers too. That was their explicit grounds. Of course, there was no risk for them in opposing it. They already had their letters. They already had their de facto immunity. Again, the government is coy about the exact numbers, but at least 156 people received an individual letter of comfort, and many others were listed in government communications as not wanted by the authorities. Again, we're talking about vicious murderers. 95 of those letters of comfort, or the people in receipt of those letters of comfort, were involved in 295 murder investigations. 295 murders. And the letters were clear. I quote from the first letter of comfort issued. "You would not face prosecution for any such offence should you return to the United Kingdom." Letters given to murderers. The government, of course, will retreat to the refuge of legal technicality. They will tell us that these letters are not, strictly speaking, an amnesty, as they left open the possibility of charges for crimes not yet discovered, as does any amnesty. The government is hiding behind legalistic language. These letters absolutely did stop prosecutions for terrorist atrocities. My honourable friend on the front bench mentions the name, John Downey. In 2014, John Downey faced prosecution for the Hyde Park bombing. He produced his letter of comfort and his trial collapsed. And what was important is what the judge said at the trial. The judge stated that there is, quote, a public interest in holding officials of the state to the promises, note, promises they have made in full understanding of what's involved in the bargain. It could not be clearer. And he concludes that it offends the court's sense of justice and propriety to be asked to try the defendant. Shouldn't even have been brought to trial. In other words, the judge was recognising a de facto amnesty. And it was only at the collapse of Downey's trial that the existence of the administrative scheme became public knowledge. Now, the Secretary of State will respond with great charm, and he'll say, but Mr Downey is now facing prosecution. That's what he'll say. I'm right. Now, one of my predictions has come right so far anyway. But that prosecution is for alleged involvement in the murder of 2 UDR soldiers in 1972, not his involvement in the Hyde Park bombing, in which he was ruled, by the way, to have been an active participant in a civil case. So we know the background. And for those 1972 murders, it's been 6 years since charges were brought, and little or no progress has been made since then. Now, the government makes much of the rights of victims, quite properly, as do I. I mean, it's been a part of my life in Parliament. But what of the rights of Squadron Quartermaster Corporal Roy Bright, Lieutenant Dennis Daly, Trooper Simon Tipper, and Lance Corporal Geoffrey Young? All were killed in the Hyde Park bombing. All had their rights explicitly destroyed. So let us be frank about the collective effect of these Blair-era concessions. 483 terrorists released from prison early. At least 16 granted mercy, granted effective pardons. At least 156 letters of comfort. Taken together, that's at least 655 people given some form of legal or administrative protection. And I say again, at least 655, as frankly, successive governments have been deliberately obtuse, I think, in how they publish these numbers. I suspect the number is significantly higher, but 655 is what we know. Yet one of the primary defences of the government's new legislation, put up by the government MPs in that Westminster Hall debate, was that the only thing granting immunity to former members of the IRA is the previous government's Northern Ireland Legacy Act. It just is ridiculous. Terrorists killed over 3,000 people during the Troubles. As far as the House of Commons Library can establish, there were no convictions for Troubles-era violent offences after the Good Friday Agreement during the entire period of the Blair government. That's what they tell me. None. I couldn't find any either, but that's what they said. The vast majority of these 3,000 Troubles-era killings remain unresolved, with no one having faced justice. And since these so-called non-amnesties, very few people have been convicted. The Secretary of State, again, said in the Westminster Hall debate, 5 convictions have been obtained for terrorist-related offences connected to the Troubles since 2012. Presumably, I assume, under the Conservative and coalition governments in that time, of course. He didn't name the cases, and I actually would say to him, I'd like to see publication of the details of those cases so we can actually understand what's happened here. Are these dissident Republicans? Are these loyalists? What are they? So just so that we know what has actually happened here. But in any case, 5 convictions for 3,000 killings, and the government is trying to maintain there's no amnesty? Really? And just to make sure, by the way, that no prosecutions could effectively be brought against the IRA, the Blair government also agreed during the Good Friday Agreement that none of the IRA weapons decommissioned could ever be used as forensic evidence in any future trial. Yeah. Shutting down. Of course, there's not many witnesses in a trial about Northern Ireland terrorism. That's a fast way to the grave. So forensic evidence is critical, and it was all ruled out of order. And for those few successful convictions since 1998, the Secretary of State referred to, what's their punishment? It's limited to 2 years because the Blair-era Northern Ireland Sentences Act, 1998. 2 years for mass murder? And instead of seeing terrorists face justice, instead we see veterans being hauled before inquest decades after the fact. I give way to my right honourable friend.
I'm very grateful to my right honourable and gallant friend. Could I just take this opportunity to point out something that the Defence Select Committee discovered in its investigation of these matters in 2016 to 2017, and that is that the 2-year maximum time actually spent in jail, no matter how horrendous or multiple the murders, also applies to British service personnel. So therefore, when the argument is put forward that the victims wish to see justice attributed and punishment given out, everybody involved in these killings receives a disproportionately light sentence. So there's no justice of a retributive sort there in any case.
Makes a very good point. I had forgotten, but I did actually see his report when he reported that when he was chairman of that committee. Now, as I said, instead of terrorists facing justice, what we do see is veterans being hauled before inquest decades after the fact. Now, this is a problem because an inquest in Northern Ireland differs in 2 critical respects from the rest of the United Kingdom. The first difference arises from a deliberate decision taken by the Blair government in 2006 when Clause 3 of the Victims and Survivors Northern Ireland Order changed the definition of victim. It ruled that anyone affected by the Troubles through loss, trauma or injury could be classed as a victim. That means if you are a proven murderer, killed in the attempt to carry out another murder, you're still classified as a victim. I know of nowhere else in the world where the law treats killers as victims. In September, the DUP, and by the way, this is still relevant because in September, the DUP, sadly not here today, but the DUP used a motion in the Northern Irish Assembly to try to restore some moral clarity by adding the word innocent before victim. What did Sinn Féin do? They opposed the motion and removed the word innocent from before victims. Why? Because the word innocent exposes the truth. It draws a line between terrorists and their victims.
Yep.
Veterans and victims are not mutually exclusive words. Terrorists and victims are. Let's understand who these so-called victims are. At Loch Gall, the greatest single defeat of the IRA by the SAS, eight heavily armed IRA murderers were stopped while on their way to kill again. They and their weapons were implicated in at least 40 previous murders, at least 40, possibly more than 200. It's very hard to pin it down, but certainly at least 40 murders. Yet because of the government's proposals and the Secretary of State's promise to the sister of one of those IRA murderers, the soldiers who stopped them faced being hauled before the courts 30 years on over an operation that prevented further bloodshed of innocent Northern Ireland citizens. And the 2006 order means that the terrorists, those dead terrorists, are deemed to be victims. And what do the veterans face? A one-sided inquest weaponised by Sinn Féin in their attempt to rewrite history. Yep. Veterans, many in their advancing years, are dragged to the witness box, made to sit opposite the families of the IRA killers, the men who died while attempting to maim and kill the innocent. The atmosphere is not one of an impartial inquiry. I spoke to, well, actually a number of veterans, but one in particular, who voluntarily attended the Coke inquest to give evidence. The coroner put to him, after he couldn't answer some factual questions, he didn't know the answers, put to him a hypothetical question to try to get him to answer a hypothetical version of the truth. And the veteran, quite reasonably, declined to answer a hypothetical question. That's not why he was there. In response, the coroner got his words, very, very cross, raised his voice and threatened the veteran with contempt of court. The man was at that point a voluntary witness. Not anymore. He was so disgusted by the process, he will now only give evidence under subpoena. He will not volunteer again. In mainland Britain, inquests exist to establish the facts, and at the first suspicion of unlawful killing, are required to stop and pass the evidence to the Director of Public Prosecutions. In Northern Ireland, inquests have all too often sought to assign blame, all funded by a legal aid machine putting huge, unjustified costs on the taxpayer. Just last month, a judicial review against the soldier who stopped terrorists, who shot one of the terrorists at Coke. It was a judicial review following on the Coke ruling. The judge, it was robustly dismissed by the judge, and the judge said, he described it as the ludicrous nature of this challenge, funded as it is by legal aid. I've never heard a judge be so critical of the award of legal aid, but plainly he thought this was ridiculous, ludicrous, his words. Now, under the government's new legacy proposals, our veterans will remain subject to suspicion and remain victims of this vexatious lawfare machine. I'll give way. Yeah.
Does my right honourable friend agree that the coroner's court exists to appease the Republicans and that all applications should go through the Legacy Commission?
Well, I agree with her conclusion, and I happen to agree that, and as I'll come back to in a moment, the view of the Republicans of the coroner's inquiry process. But it comes back as well to the issue that my right honourable friend raised as to what the punishment was. Because for a decent, ordinary, law-abiding soldier, the punishment is in the process here. Being dragged back, having this hanging over you for years, for decades. You know, the uncertainty that they face, their sleepless nights, the stress it brings to them and to their families, you know, their wives and children, both worried in their own right and worried about their husband or father. And that, I'm afraid, is what the IRA and their sympathisers want. That's one of the reasons the IRA consider the very fact of Loughgall being referred to an inquest as a victory. They see that as a victory. That and the fact that it allows them another chance to rewrite history to fit their own bogus claims. Now that's why in their letter, now been repeated in this chamber a number of times, their letter on Remembrance Day, 9 four-star generals wrote, and I quote, "By extending the same protections to those who enforce the law and those who defied it, the bill becomes morally incoherent. It treats those who upheld the peace and those who bombed and murdered as equivalent actors in a shared tragedy." And they go on to highlight the immediate effect of this. Bear in mind, this is having an effect right now on our current serving armed forces. And they said, highly trained members of special forces are already leaving the service. These are the men and women who quietly neutralise threats and protect lives every week. Their loss is significant. It's a direct consequence of legal uncertainty and the erosion of trust. And I can attest to the fact that that is true. These are the reasons, by the way, that our veterans hate this new legislation and view it as grotesquely unfair. It also raises the question of who the government are trying to appease here. When the government announced its policy, it was not done in this House. I think it was done on Friday, but certainly it wasn't done in the House, and it was in a joint statement alongside the Irish done Easter. The Irish government is being treated as an independent party to these troubles and brought into the Reformed Legacy Commission, established by the new bill, as a party who is assumed to be acting in good faith. Well, I'm afraid that's not true. There is overwhelming evidence showing the Republic providing sanctuary to IRA terrorists during the Troubles.
On the run.
As the Kingsmill Inquest, the terrible tragedy, the Kingsmill Inquest confirmed, terrorists exploited the porous border ruthlessly. The IRA committed acts of terror in the north and used the Republic as their shield, a base for planning, for training, for storing weapons, and a course for sanctuary. Violence in the north, sanctuary in the south. Consider the brutal murder of Corporal James Elliott in 1972. IRA members abducted him at the border, dragged him into the Republic, tortured him for 2 days, and shot him dead. They sent his body back across the border, booby-trapped with 500 pounds of explosives and 6 claymores. What did the authorities of the Republic do? They charged 2 individuals not with murder, but with possessing explosives. When SAS Captain Herbert Westmacott was murdered, the killers escaped jail before they could be sentenced. Where did they flee? Straight across the border, aided by their comrades. And if you need a third example, look at the Omagh bombing, carried out after Good Friday Agreement had been signed. The bombing that injured more than 200 people and tragically killed 29 innocent civilians, one of whom was pregnant with twins, was both planned and launched from the Republic.
It was indeed.
Despite this, and notwithstanding the call from a Belfast High Court judge for an investigation on both sides of the border, the Irish government refused to authorise a separate parallel inquiry. The pattern's unmistakable. And in some cases, agencies of the Irish government crossed the line from passive antagonism into active complicity. Former IRA intelligence officer Kieran Conway has admitted how leading members of the IRA were tipped off before Garda raids by Garda Special Branch. This was more than turning a blind eye. It was agencies of the Irish state actively participating in the subversion of justice. There are countless incidents laid bare before us, each one making this point plain. The most horrible one in my mind is in 1989, 2 senior Northern Irish policemen, Chief Superintendent Harry Breen and Superintendent Bob Buchanan, were shot dead in an ambush as they crossed back into Northern Ireland. After almost 8 years of detailed investigations, the Smithick Tribunal determined that the Irish police colluded with the IRA in organising that attack. Between 1973 and 1999, the Republic of Ireland turned down 102 extradition requests, choosing to view murders in the north as political acts. The Irish state is not a neutral bystander. It's not some impartial observer. It was, in practice, a partisan actor, an actor that for more than 30 years has deliberately turned a blind eye to the atrocities committed by the IRA. For years, our armed forces have properly faced scrutiny for their actions during the Troubles. And we have answered that scrutiny with honesty, never to erase the truth, but to confront it. Yet we hear nothing of the de facto amnesties given to terrorists and murders, nothing of the collusion that allowed that terror to take root, and nothing from the government about preventing the vexatious pursuit of our soldiers who are guilty of nothing but bravely serving their country during the dark days of the Troubles. Instead, all we see are relentless attacks on those soldiers. No doubt, relentless attacks. Introducing doubts about the legitimacy of their actions, and of course the weaponisation of the entire legal process. We had a warning of that, again, in that letter on Remembrance Day, when those generals in the Times spoke of the damaging effects of lawfare, and specifically the risk posed by the government's legacy proposals. They said, the government's Northern Ireland Troubles Bill and the legal activism surrounding it risk weakening the moral foundations and operational effectiveness of the forces upon which this nation depends. Presented as a route to justice and closure, the bill achieves neither. This lawfare is a direct threat to national security. The government would do well to heed those warnings. Failure to do so brings injustice for those who served our country with honour and threatens the future effectiveness of our armed forces. Every would-be enemy of the United Kingdom is watching how we handle this matter and looking at plans for retaliation in the law courts as a way to avenge their defeat on the battlefield. As the generals warn in their letter, make no mistake, our closest allies are watching uneasily, and our enemies will be rubbing their hands.
Before I call the Secretary of State, it's a short reminder we should not mention or repeat the names of individuals that are subject to proceedings. I call the Secretary of State, Hilary Beck.
Well, thank you very much indeed, Madam Deputy Speaker. Can I congratulate the right honourable gentleman on having secured this debate The legacy of the Troubles cast a very long, dark shadow over the lives of so many people in Northern Ireland and across the United Kingdom, and some of those people the Right Honourable Gentleman has mentioned. There are many, many, many others amongst the 3,500 or so who lost their lives. And I would just say it's really important in these debates that we acknowledge all of those affected and not just some, even though the some are, of course, extremely important. And I would also say to the benches opposite, at some point, they will need to acknowledge that the last government's Legacy Act had no support in Northern Ireland. And if we are to move legacy on, if we're to move legacy on, there needs to be support for the legislation, and that is why the government is seeking to change it. Now, the government, of course, takes the concerns of veterans very seriously. Our commitment to Operation Banner Veterans is unshakable, and the Troubles Bill we'll debate next week will put in place the strongest possible protections for them, none of which were in the last government's Legacy Act. Now, the Right Honourable Gentleman talked a lot about prosecutions. I mean, he knows full well decisions on prosecutions are taken independently by the Public Prosecution Service in Northern Ireland, and nothing this government is doing will change that at all. The system will be exactly as it has been in the last 27 and a half years since the Good Friday Agreement. I would say just on Loughall, the reason there is going to be another inquest is because the Conservative Attorney General 10 years ago ordered that the Loughall inquest take place. That is the fact. And since nothing has changed in the past 27 years, well, why don't we just look at some facts about prosecutions? Since 2012, there have been 25 decisions to prosecute individuals for trouble-related offences. 6 of these have resulted in convictions. 3 were Republicans, 2 were Loyalists, 1 military, the soldier in question receiving a suspended sentence. If you look at the current cases, live cases that are before the courts, 6 Republican, 1 Loyalist, 1 former police, and 1 in the military category. What do the facts show? The vast majority of prosecutions are against former paramilitaries. And when the Right Honourable Gentleman suggested at one point in his speech, well, five or so prosecutions for all these deaths, he does ignore the very, very, very large number of paramilitaries who were sent to prison during the Troubles, including many of them for murder. And that was a very large number compared to the numbers, as he well knows. Well, on the subject of immunity, I, of course, noticed the letter that was published in the Times. But when I have said repeatedly that the Legacy Act, the current one, would have granted immunity to terrorists, I hear from a sedentary position, well, that's not true. Let me just quote from what the Legacy Act says. Section 19, quote, "The ICIR must grant a person immunity from prosecution," end of quote, if certain conditions are met, that they've asked for it, that the information describes conduct which formed part of the Troubles and is, to the best of the person's knowledge, true, and that the Commission is satisfied that the conduct would have exposed the person to criminal investigations. And shouting that's not true when it is true, and that is one of the reasons why the Legacy Act had no support in Northern Ireland, because the families of all those who saw their loved ones killed did not want their killers to be granted immunity. And as the Right Honourable Gentleman well knows...
Order. The House stands adjourned. On your feet.